Tonight, I will discuss a new thing which is unexplorable uh, last century, more than last century, and the matter is bail. I will tell you new many things to you about the bail matter. For long-term practice, you may say it for more than century. We are seeking bail from the court, but this is highly illegal and not acceptable. Bail is not a matter to be sought from the court. Rather, bail is a matter to be given to the court. But yet that throughout the last century, we are seeking bail from the court. Now, I will shed a new light on this matter, what actually bail means. If we look into the dictionary, that is the Oxford Dictionary, the word bail has been defined as, or the meaning of the word bail is given as, bail means sum of money that somebody agreed to pay if the accused fails to appear at the trial. What we have seen here, bail means sum of money. The same thing we can see from the title of section 496 of the Code of Criminal Procedure 1898. The title of this section contains in what cases bail to be taken. That is, it says bail may be taken. Bail is a matter to be taken. From whom? From the accused. Whenever the accused appears or brought before the court in non-bailable cases, and while he is in custody and prepared to give bail, the court shall release him on bail. The section 496 of the Code of Criminal Procedure 1898 says this: while the accused is in custody and prepared to give bail, that is, the bail shall be given by the accused. To whom? To the court. Then the court shall release him on bail, and the court will release him on bail. So what we have seen from this contents of the section and title of this section, in both places we see bail is a matter to be taken from the accused. When bail is a matter to be taken from the accused? While he is in custody. The same thing we can see from section 498. The later portion of the section says the court or the police officer, as the case may be, may reduce the amount of bail. Then from here we clearly see that bail is an amount that may be reduced by the police or the court. In the same way, section 497 of the Code of Criminal Procedure 1898 says in which cases bail may be taken. This section says if any person is arrested or appears before the court or surrenders and accused of bail, non-bailable offenses. In that case, the court may take bail from him or not. It is the decision lies at the hand of the court. As because the allegation of non-bailable offense has been brought against the accused. That is why it is the power of the court. Whether the court will take bail from the accused or not, it will be decided by the court. In the same way, under section 499 of the Code of Criminal Procedure 1898, we can see this section clearly says before a person released on bail or bond, this section clearly says as a person arrested or appear before the court, and if he seeks his release, the court may either release him on bail or bond. Actually, the matter would be the release of the accused who has been arrested. But in place of release, we are saying or submitting before the court, sir, we want bail. Bail is not a matter to be sought from the court. Bail is a matter to given to the court by the accused. By the accused. If we look into form number 3, given in 5th schedule of the Code of Criminal Procedure 1898, the same thing, that is the bail, is mentioned as a sum of money. But for reasons unknown, we see that the culture is prevailing in criminal cases, criminal courts. The advocates are seeking bail from the court, which is illegal, which is absolutely wrong. It is because of the Bengali law books. All the Bengali law books, mostly written by the students, and sometimes some prominent person also, translate the section 496, 497, 498, 499 of the Code of Criminal Procedure 1898 wrongly. Because of mistranslation, the person who reads law in Bengali and Bengali books, they are in mistake. The first mistake committed by the person who wrote the book, and from him, the person who read his books, they are committing mistake. What I want to see you, the people in the legal arena, you as an advocate, never ever seek bail from the court. You may seek from the court release on bail. If you are a lawyer for the accused, you are submitting before the court, you are to seek release. And whenever you seek release, and that if the court is satisfied, if the court wants to release the accused who has been arrested or appears or surrenders before the court shall release him on bail. That is, bail is an instrument. Bail is an instrument must be executed by the accused, promising that he will appear at the trial on the date fixed by the courts. If he fails to appear at the trial on the date fixed by the court, he would pay some money mentioned in the document, that is in the bail. Bail is an instrument. Bail is an instrument. Bail is a document, and it must be signed by the accused. And the court shall release him on bail containing the amount of money mentioned in it. And if the accused fails to appear at the trial on the date fixed for the trial, the court may forfeit the amount of bail and may initiate a miscase under section 514 of the Code of Criminal Procedure, and may held liable to the guarantor or surety. I will discuss the matter of surety or guarantor of the bail in the next video. I will not discuss that matter here. But what I wanted to see you, for more than century, we are committing mistake. Or most of the people in the legal arena are doing mistake, seeking bail from the court of law. You, as a lawyer, whenever you seek bail from the court, you are to submit before the court by saying that, sir, I want release of the accused on bail, not simply of bail. Sir, I am seeking bail of the accused. You are to seek release of the accused on bail, as because bail is an instrument. Bail is a document, and it must be signed by the accused mentioning an amount of money, which is not cash. It is the promise of giving money if the accused fails to appear at the trial. Hope that I can clear you a new matter, which is a great blender in our criminal courts throughout the country. So thank you for watching this video. For the first time, I am shedding the light on this dark matter, which is mostly unknown to the legal fraternity. We are conducting bar professional training course. The person who want to be efficient lawyer within a shortest possible time, you may join our program, and all our program conducted by me over Zoom app. If you want to be a good lawyer, efficient lawyer within a short span of time, you may communicate with me over the WhatsApp number given at the WhatsApp, our description box. Thank you again on behalf of Badullah Academy.